Sexual harassment, relatively speaking, in terms of the development of American law, is fairly new. It really came out in the 90s. You know, it always strikes me that for anyone who's a fan of musical theater, there's a show called How to Succeed in Business Without Really Trying, which was a sort of a parody of corporate America in the 60s. And there's a song in that show which is very tongue-in-cheek, where all the men there get on stage and they say, you know, elbowing each other, "A secretary is not a toy, no, my boy, not a toy." And it's all about the fact that one of the perks of having a secretary is that you can harass her. And that was kind of accepted. If you watch Mad Men, that show, you see that environment where you think if you're a boss, you can expect favors, sexual favors from your female subordinates. And over time, in the 90s particularly, the law started changing, and as a creature, as a subset of gender discrimination, the concept of sexual harassment was accepted by the courts. And just very quickly, there are two types of sexual harassment. There's quid pro quo, which in Latin means this for that, which is an exchange, where a boss says, you want to become full-time, you want to get a raise, you want to get a better job, you want to get a better assignment, sleep with me. Or some sexual act or some sexual arrangement. That's quid pro quo. When that happens, particularly if it's a supervisor or someone with superior or a superior status than you, the company is liable. If you say no and are fired, or if you feel pressure to submit to that advance and can prove it, and it's someone with power over you, that act in itself, if it's quid pro quo, a company is liable. The more prevalent type of sexual harassment, though, the ones that are coming up now in the trucking industry, and there's some very exciting news in this area, are hostile work environment cases. Probably most of you have heard that phrase, a hostile work environment. So, again, relatively, when I say relatively recent, it's about 30 years old, the concept, maybe 25, where at an environment, the terms and conditions of your employment, which sort of synonymous for environment, or at least the conditions of your employment, are rendered hostile or uncomfortable or intolerable because of your protected status. Here, it's usually women, but there are sexual harassment cases, and I've had many where men are the victims. And it's the idea that because of the conduct of the harasser, you are made to feel deeply uncomfortable, and your environment is materially changed at work. Now, harassment takes on many forms. The most egregious is physical harassment. And in the trucking industry, unfortunately, there are numerous incidents of sexual touching, even rape, forced sex, other kinds of touching, slapping the buttock, slapping the thigh, and you can imagine a whole range of touching. After that, verbal harassment. Comments about directly, and this is significant. In the hostile work environment case, the harassment does not have to be directed necessarily at you. If you are aware of it, meaning if you're, think about an assembly line, and if the boss is coming along and constantly putting his arms around the woman sitting, standing in the line next to you, and you're there for weeks or months saying, when is it going to happen to me? I'm next. Your environment is rendered hostile. And so one of the weapons in a hostile work environment is what happens to other women who are similarly situated is relevant to you. And that gives your case a lot of power, because the environment is now the focus of the litigation, not the individual plaintiff, the environment. And crucially, and this is going to come up in a few minutes, in a groundbreaking case that just came out a few months ago against CRST, a class of women were certified, a class action in sexual harassment, which is very rare, because the focus was on how the company responded to the complaints of harassment, not the individual incidents. Okay, so you have a hostile work environment, and really the elements there is first you have to establish that there was sexually offensive conduct. You want to also establish company liability. How do you hold a company liable? See, company said, and this came up about 20 years ago, look, IBM, 30,000 employees. If Supervisor Jones in Toledo, Ohio, touches Miss Smith, why are we responsible? That's a rogue employee. We have a policy that says it's against our policy, and we have a complaint procedure. Why should we be responsible for that? We fired him when we found out about it. No liability. And the court said the following. This is the famous Farragher-Eller decisions, which created a whole dual affirmative defense for companies. First, if a supervisor uses his or her power to harass an employee and uses the power to fire, reduce pay, transfer, assign, uses some element of company authority and power to affect the employment relationship, the company is liable. Because that supervisor is acting as an agent of the company and using the company authority to advance the harassment. But if there's no what's called tangible employment action, if there's nothing affecting pay or job status or assignments connected to the harassment, it's just physical or verbal harassment, it's just environmental harassment, can the company be held liable? The answer is yes, but the companies have a dual defense. And here's really where the meat of these sexual harassment claims, and particularly in the trucking industry, really is, which is, can they sustain those defenses? The burden of proof of these two defenses, the Farragher-Ellis defenses, is on the company. And the defense is, did they take reasonable measures to prevent and correct harassment? Prevent means simply, really, in most cases, a paper policy. They had a policy that said it's against the sexual, we don't tolerate it. And they have a complaint procedure, where to go. And then the second is correct. Did they take prompt remedial action? And that's really where the action is. Let's go for the defenses now because I'm there, and then I want to go back to something else about what women can do individually and what they should do. So, if they had a paper policy, what did they do with the complaints? Did they respond? Did they investigate? I don't have time, but I can tell you, I've examined many human resources officials from major companies, who completely mishandled investigation. I had a case against an international security company, and they didn't even examine the complaining party. They didn't question them in person. They did it over the phone. And then when I asked for the notes of the investigation, which obviously you have to document these investigations, they didn't have them. They lost them. So, how a company responds to a complaint of sexual harassment is critical. Did the employee complain? Now, it's not so simple. The company says, no complaints, no harassment. You didn't complain about it, it didn't happen. Just a general rule in the harassment world and in the employment law world, they say, if it's not in writing, it didn't happen. Because if the he said, she said, or he said, usually is an obstacle. If it's just a single person's testimony. I've overcome that. It takes a lot of work. It takes a strong plaintiff. This is particularly a problem in the trucking industry, sexual harassment. Because unlike most employment settings, whether it's a restaurant or a store or an office, where there are other employees around, typically in the trucking setting, it's one woman and one driver, or one woman and one man in a truck. And so it's really just he said, she said, with no one else around. And I just want to read something which is incredible. In this Sellers case, which is the case out of Iowa in March 2017, one of the reasons why the court there granted class action status to over 100 women who had alleged sexual harassment, again, which is very unusual. The reason why it's so unusual is, unlike a wage case in which everyone is saying, I don't get paid for rest breaks, and it's the same policy. If 100 different women claim sexual harassment, it's usually there are differences in what occurred. There are differences in harassment, there are differences in the complaints, there are differences in the proof, and so courts say, how can we certify a class that has 100 different claims? It's not susceptible, or it's not conducive to class treatment. They're all different. There are too many individualized differences, is the language of the courts. The lawyers for the women, one of whom is a fellow alumnus of mine from Columbia Law School in New York, and I know Josh Friedman, they were very smart. What they did is they said, and we did this in our case against that big company, instead of making it about putting the women on trial, we put the company on trial. And there they said the focus is on the company's failure to respond to complaints. And this was one of the first point the judge seized upon was that because of CRST's policies and procedures, it was essentially, they made it impossible for the company or the women to corroborate complaints. So here's a question that the lawyer asked, I think the head of human resources of CRST. Question: if the allegations of harassment concern behavior that occurred on the truck while the drivers are there together, would it ever be possible for you to find that harassment was corroborated based on evidence other than a third-person eyewitness who was on the truck seeing harassment? Answer: not unless there was an admission by the accused individual. So, if a woman comes and complains about harassment on a truck and there's just the woman and the male driver, there's no possibility of corroboration, the company is saying, unless the driver admits it. Now that's incredibly bad and incredibly unfair. What about the company's duty to do an investigation to find out, has anyone else ever complained? To ask other women what their experience was. What about interviewing the complaining witness herself? I find, in the way I have found this to be a very effective tool, is the power of specificity. If a complaining party can tell you in great nuanced detail about who, what, where, when, how, of what occurred. You know, we all know, you know, if you think about, you know, as a parent, a 16-year-old child comes in at 4 a.m. and the parent said, I want you home at midnight. And they give you a generalized excuse. Oh yeah, I was out with a friend. Where? Well, you know, a party. Where? Oh, you know, some party. And it's vague and kind of, you know, unspecific. Chances are the person's lying. If they come in and they say, you'll never guess what happened. You know, Nancy, my best friend, she got drunk and she threw up all over her clothes, and she couldn't go home because her mother would see. So we had to go to Debbie's house, and she had to wash the clothes, and all of a sudden, whoa! I don't think my kid can make that up. I've had defense lawyers tell me, after cases have settled, Steve, we read your complaint and we said, you can't make this stuff up. So the company, they just abdicated their responsibility to say, unless we have a driver admission, we can't corroborate. Well, maybe the only corroboration you need is a thorough interview with the complaining, and to look that person at the eye and see the truthfulness. And very often, you see someone who's talking from the heart, and I've seen many times tears rolling down his or her face because of their experience, and those tears are the marks of truth. So they found that there was an absence of corroboration of complaints, and that was a systemic failure. Just to quick other examples, they found that there was a failure to impose discipline on the harasser. Very often all that happened was the harasser was assigned to male-only trucks, systems. So they permitted to continue, and then just switched for a short period of time. That's systemic. That applies to many drivers. The driver managers also showed they were proven to tolerate harassment and failed to act. The complaints were made by women to driver managers. They did nothing for months, sometimes longer. And that failure of the driver managers to act was also a systemic failure. This happens all the time. There's the harasser, and then there's the complaining party. The complaining party is removed from the workplace. Unpaid suspension. The harasser is permitted to stay. Very unfair. It's a setback for the complaining party. And again, the court found that this was done on a broad-based systemic basis, not about the individualized case, about the company's response. Transit and lodging costs, if they move it. The woman calls in the middle of the road and says, I'm in danger. They make her stay at a hotel and travel. They'll pay for it, and then they deduct it from the paycheck. Again, imposing a monetary cost on the complaining party. Across the board, systemic, and that was found to have been a basis for class certification. And then what they do is often they say they're going to extend the student driver training period because the student is removed from the lead driver's truck, and now she's got to go back and start again, and that's less money for her. She's not making money. Again, punishing the accuser. But the key is all of those 6 points are what the company did, and they found that that was systemic, broad-based, and therefore on those common questions a class could be certified. You don't need a class necessarily. I've handled cases with 1 plaintiff, 2. I have one now with 6, 23, 27, 150. I will just say one thing for women out there. Two is not just two women suing or two people complaining is not just twice as effective as one. It's a multiplier effect. I know personally from defense lawyers, whenever there's more than one person, it's a much more difficult case to defend and the companies get much more frightened. I've seen insurance policies from insurance companies who insure against these kinds of claims, and whenever it's 4 women or more, it's considered a mass or class case, because companies know if you have 4 women or more, it's a problem. And so what I would say to women out there, keep your eyes and ears open. Very often, the harasser is a repeat offender. I've seen that over and over again. And if he's harassing you, he's harassed someone else, or he will. Talk to him. And whether it's in person or perhaps through social media, be careful with what you put on social media, but nevertheless, you can reach out, you can find either directly or through friends and colleagues, and you'll be surprised how people, have knowledge. And once you have that, you're off to the races. 2 last points. Complaints often are put on the employee as an obligation. Not so easy. It's embarrassing. Most people are afraid to complain. They're afraid of the consequences. They're afraid of retaliation, criticism, ostracism, blacklists, things like that. So the Equal Employment Opportunity Commission has come out and said, even though the failure to complain can be asserted as a defense by the company, there's 2 reasons that have been recognized by the courts why the failure to complaining should not be fatal. One is fear of retaliation. If you can show that you have a bona fide legitimate fear of retaliation, then your failure to complain can be excused. If you can point to a prior incident in which someone's complaint resulted in them being not just fired, prejudiced in some way, maybe having to repeat the training or other things, a poor assignment, that's a reason to be excused from not complaining. The second one, which is interesting and I think really applies in the trucking industry, is futility. If you can show that you had a reasonable basis to conclude that a complaint would be futile because you knew it'd been going on forever, nothing's ever done, even when people complain, the harassment continues, you are excused from complaining. And I've had success in cases overcoming the defense. We never got a complaint by showing it was futile and there was a fear of retaliation. There's more to say on that in arrange an hour, but I think I'm getting close to 8 or 9 minutes.
Time is up. I think sexual harassment to me, as a company owner, is very, very subjective. Very subjective. To say you look beautiful today, you could actually manipulate that into a sexual harassment case, where it's so the threshold of you as an attorney, the burden of proof is very, very low for you. So me as a jurist would be setting on that, and the scale is already in the defendant's favor. It's your burden of proof. So sexual harassment is very, very subjective. So I think opposites attract, and it's just human nature for that to happen. Going overboard, I don't think that you're beautiful or you look beautiful today, or it's all a choice of words. You look nice today, or you look beautiful today. So now we've just had a step from nice to beautiful, right? So at what point between nice and beautiful does the sexual harassment come into play? So that's a very fine line that us as companies have to operate under. And when you start looking at employment law, I mean, we're just hammered and hammered and hammered. And there has to be some type of common sense, you know. He rubbed me, or he rubbed me with his buttocks while I was getting coffee. Well, on my buttocks. I mean, it's so subjective. So I think that think attorneys, and nothing against attorneys, because attorneys are there for a purpose, but I think it goes way overboard. And like you were saying before, all depends on how broke the attorney is. So I think it's very, very subjective. Any sexual harassment case, to me, going into and sitting on a jury, the defendant, the scale is weighted in his favor from the get-go.
The Supreme Court of the United States and courts throughout the country have agreed with you and have responded this way. The standard is harassment must be severe or pervasive. Severe means really bad, and it can't be beautiful, it can't be nice, it can't even be sexy. Hey, you look sexy. It can't be. No, it has to be something. Severe is egregious. It has to be bad, or pervasive, which means frequent, regular. And so, I can tell you now, cases are dismissed all the time for the kinds of conduct you described. And even before they get dismissed, most lawyers that I know would never bring those cases. They wouldn't even bring it for that kind of conduct.
Right.
And so, because the likelihood of success is non-existent essentially. So when it comes to that, and beyond that, the standard isn't just severe or pervasive. It has to be what a reasonable person, not what Janet Smith experienced or thinks. What would a reasonable person who experienced what Janet Smith experienced react, or how would they perceive that conduct? And so, slight petty insults are not enough. But if you have severe or pervasive, and when you have, for example, a serious act of touching, right? That in and of itself could be not brushing buttocks to buttocks, getting coffee, but something intentional, deliberate. I'm talking something, really crosses the line, and everybody knows it. That would be enough. But you have a point, and the courts have responded.
I'd like to follow up on that point. We had a case where a female trainee was raped by her trainer for a major trucking company whose name you would know. Sometimes I use names if it goes to decision, but a lot of settlement agreements have confidentiality clauses. She was raped by her trainer in the parking lot of Lowe's. Now, that definitely was serious touching. We lost at the Equal Employment Opportunity Commission. EEOC is a sort of like a step through which we all have to go. There are a lot of bad cases out there, but the win rate, and Mr. Arenson may agree with me, but the win rate at EEOC for discrimination cases, whether it's race, religion, age, whatever, is about 3%. So it's not like people file these cases and then somebody writes them a check. We have a lot of steps to go through, and good lawyers don't take cases where somebody says, hey, beautiful, how you doing? Once we get past EEOC and we get a right to sue letter, then it goes usually in the U.S. District Court, and there's a procedure called summary judgment. In the employment, in the federal courts of this country, in employment cases of all types, employment discrimination or harassment type cases, race, religion, age, sex, the win rate on a summary judgment, which means, hey, is there enough here to go to trial, enough of a material fact dispute? Employers win those motions at about 75%. So it's not like we have to have a really good case if we're going to win it, because we have to win it at all sorts of levels. And most of those cases get appealed then to the circuit courts. So it's like, so I don't think that those cases, the so-called frivolous case, I don't know, it could be, some lawyer in need of money, and some employers will just write a few $1,000, but I don't see that. I don't get called with a lot of frivolous cases. When I get them, I shouldn't say it. We get somebody, somebody said something to me, looked at me sideways, or, made a joke about me being black, or, called me beautiful. So I said, big deal. Let it go. Go find somebody else. But by the way, here's your deadline.